today's docket. That's case number 109121 in the matter of the marriage of Stevenson v. Papineau.
May it please the court, John W. Fresh on behalf of the appellant, Gregory Papineau. Mr. Papineau is also present with us this morning in the gallery. Mr. Chief Justice, I request to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you very much. The facts of this case are not complicated and not very long. I think the Court of Appeals commended Mr. Ferris and I for the brevity of the record in this case. Essentially, we have parties who were married for several years, have 2 sons, got divorced. Primary custody of the children was placed with Ms. Stevenson. Mr. Papineau was ordered to pay child support. He did so. At some point, his health deteriorated to the point where he was no longer able to work. He'd been a nurse. And he had the good fortune, and his children had the good fortune that he had a long-term disability insurance policy available as one of his employment benefits. He applied for those benefits, began to receive them, used those benefits to pay his monthly child support obligations. They were paid while he was in the hospital. They were paid while he was undergoing surgery. They were paid rain or shine, no matter what. At the same time, he filed an application for Social Security disability benefits. Social Security disability benefits, as I'm sure you all know, are available to people who have paid in to the Social Security system, as Mr. Papineau did during his working life, and who meet other criteria to receive those benefits.
And that portion of the Social Security disability that's payable to the children was payable to his ex-wife as the payee for those children.
Yes, sir.
And that money is precluded by federal law from being used for any purpose other than for the children, or at least it's not subject to attachment or paying any judgment in this case. In other words, your client could not have gotten a judgment and collected for overpayment and collected it from those as a matter of federal law. Can any of the, let's make it simple, can any of that Social Security that went to the ex-wife for the benefit of the children, can that be paid back to him legally to reimburse for these payments you're after under federal law? It was my understanding it could not.
I would agree it probably could not, and I think the analogy there would be had the mother of the children simply endorsed that check back over to Mr. Papineau and she received it. I think that would have been improper under her obligation to the children, correct?
And so your remedy then would be what? Just to have an abeyance for child support obligation for a period of time, or how do you seek your remedy?
Well, I think the remedy would be for the mother to pay that back.
Kind of like quantum merit. I mean, that's what it sounds like. Just an sort of an equitable.
Well,
argument.
And I think, Your Honor, that we really do have an equitable situation here. And I think it was mentioned
that the equities are there for the children. I mean, why should the mother pay out of her own pocket when this money went to the children? I mean, it's not quantum merit from the mother, because as fiduciary of this money, she's supposed to spend it on the kids. So
I think both parents have a legal obligation, a moral obligation to support the children. And I think that had Mr. Papineau not had the luxury of the disability insurance to pay those payments. The mother would have been responsible for them, I suppose. She would have been able to recoup them maybe from Mr. Papineau after the fact. But I think the equity really doesn't favor the double payment that's been made here. Mr. Papineau did nothing wrong. In fact, Mr. Papineau did what he was legally and morally obligated to do. He provided support for his children.
I don't think anyone's going to deny that we want to encourage fathers to pay, to make these, and it's admirable that he made the payments and didn't quit paying when he became disabled. But the problem is, how do we remedy that when he really doesn't have any more obligation of it? I mean, he didn't have to pay anymore because Social Security is taking care of that.
Well, all right. As I think you said in an earlier argument this morning, I think that's a difference without a distinction, because he does have to pay it. He does have an ongoing child support obligation, and if for some reason, if tomorrow the Social Security system went bankrupt and couldn't pay that, he would still have to pay it.
But it's not easily handled with a credit against future payments.
It is not, Your Honor, because of the set-off that's authorized by the cases.
And I think that's where we are right now, is where's the money going to come from to rectify or to recompense without taking it away from the children, and we can't do that.
Well, right. I suppose if you're precluded from doing that by the federal law governing the Social Security disability benefits being used for the children, I think that does create a difficulty. I think the dissent in the Court of Appeals did suggest some different things that could be done there, and how that could be approached. And I think again, the fundamental fairness of this between the three parties involved, and the three parties involved would be Mr. Papineau, the children's mother, and the children. And I think certainly the children are entitled, and the children are entitled to support legally, morally from both parents, and both parents have that obligation. But I think in that scenario, the children have the benefit of the support that they're entitled to. The mother has the benefit of having that support in her household for the children, and Mr. Papineau has nothing. In fact, he's paying, and I understand the relevance, and I won't dwell on the issue of the subrogation by the disability carrier, but in effect, he's going to pay 3 times in this case, and that's just fundamentally unfair.
You're saying that the Social Security lump sum is essentially just a windfall to mom and kids.
Mom and kids, Your Honor, yes. It is, and I think the cases use the word gratuity, and I think those cases, the Kansas cases, the Homan case, the Andler case.
Well, the cases talk about the child support that was paid being a voluntary gratuity, which is different than the Social Security lump sum, which, as I characterized your argument, you're arguing it is essentially a windfall.
It is.
And is that because the Social Security lump sum would have been creditable against any arrears?
No, it's a windfall because there were no arrears.
Right, but it would have been creditable if there had been arrears.
It would, under the
I'm
cases.
just getting at the difficulty of this case, that you said your client did nothing wrong when I use wrong in quotation marks. I mean, kind of what he did wrong here was continue to pay.
Well, Your Honor, and that's the other part of our argument, and I think that's the argument that other courts who have decided this favorable to the position we take have used, and I would refer to an Ohio Court of Appeals opinion that came out about 3 months after our decision. The court basically says that the paramount goal of child support is to promote the best interests of children and to avoid financial hardship to children of divorced parents. If we were to limit a payor's credit entitlement to only situations of unpaid support, we would encourage disabled payers who nonetheless have the ability to pay support to terminate child support payments in anticipation that potential future Social Security disability payments will eventually make up the shortfall. And that was an argument that we made in the Court of Appeals, was the policy here is that children should receive a support, and you have parents who become disabled who have maybe the wherewithal to pay, whether that's through a spouse they may have now who's willing to step in, through disability insurance like Mr. Papineau had, through other assets, they could sell their boat or cash in a retirement account or whatever to pay their child support, but they do that at the risk, or at the state of the law right now, that they could double pay if and when their disability comes through. And it's a disincentive. The word disincentive was used, I think, by myself in the Court of Appeals decision, and I think in some of these other state courts. It's a disincentive. And I think, and we were asking, I was asked at the Court of Appeals if Mr. Papineau had filed a motion to modify his support when he became disabled, and I was not certain of the facts. And I will tell you that he did. He did file a motion, and it was denied. And I think it was rightly denied, because when the trial court gets a motion to modify child support based on a change of income, they look at what are your resources. And Mr. Papineau's resources included disability insurance. So no court is going to reduce child support if you have the resources. And even if they do reduce it, as I think Judge Atchison says in the dissent, they would never reduce it to zero if you have any ability. So, and probably if you didn't have an ability, they still couldn't reduce it to zero, because they have discretion, one, to impute income, and two, they have an obligation to see that the children receive something, or at least have an entitlement to something.
Does the record tell us if Mr. Papineau has financial obligations other than the child support? For example, does he pay medical insurance or share in the expenses of medical expenses, or any of those other things that Judge Atchison talks about as a possible equitable means to remedy the situation?
I don't believe any of the underlying divorce pleadings are in the record. No, Your Honor. I do think, as typical in divorces with young children, the court in this one apportioned responsibility for medical insurance, responsibility for uninsured medical expenses, everything that would be in a typical case.
You mentioned a subrogation claim. Is that in the record, or is there one? What is the status of it?
It is pending the outcome of this appeal. There is, the disability insurance carrier is subrogated to whatever they paid out in total, and that includes any monies that were received either by Mr. Papineau or the children. So they want to pay back everything they paid out. But there's no documentation of that in the record other than the stipulation of facts. No, the insurance company is not a party to the underlying action. I believe I'm out of time unless there's other questions.
Any more questions? Thank you, counsel.
May it please the court, J. David Ferris, on behalf of the appellee, Mrs. Stevenson. I have reviewed this case and been living with this case for quite some time, and I think Justice Johnson probably hit it on the nail on the head. The question is, and it was raised hypothetically in Holman by the mother, is who pays back? In Holman, if she said, if all support payments are made by the father and then I receive a lump sum, do I have to pay that money back? And the court didn't specifically answer that. The court said a majority of the jurisdictions say no. The overpayment solely for the benefit of the children, or the child in that case. Tabor reaffirmed the Holman decision and stated that a majority of the majority views is that no reimbursement is required because overpayment is a gift to the children. Now, the dicta in both of those cases is obviously not controlling to this court, but it is persuasive. And I think that's the decision that falls upon you today or in the future is, what do we do in situations?
But
like
is it equitable?
Pardon me?
Is it equitable?
Is it equitable for the mother to keep the payments or to pay them back, Justice Johnson? I want to
Is, you said it's persuasive authority to consider the lump sum as a gift to the
to
children.
the children. That's
Is
correct.
is that an equitable result
I think it is.
under these circumstances?
Under these circumstances, we talked about, Justice Rosen, you asked about a subrogation claim. You can't subrogate. The kids aren't party to that contract. Their money's never going to have to go back. Now, possibly Mr. Papineau's money's going to have to be returned, but he received a lump sum Social Security disability payment.
Rather than approach it as a matter of equity, I think of another way to approach it, and that's as a matter of economics. If we were to continue with the characterization of these as overpayments, voluntary overpayments, I mean, I could conceive of an argument, at least, that a rational economic actor is not interested in making overpayments, and so from an economic perspective, I mean, you see where I'm going with this.
Yeah, absolutely.
As we characterize this as an overpayment, it is a disincentive, and in fact, it's a pretty strong disincentive. Once people recognize that these are overpayments, I mean, in theory, they could have an argument that they're not even obligated to make the payment if it's truly an overpayment.
I understand, Justice Siegel, exactly what you say, and I think that's the dilemma we face. Because if you look at cases throughout the United States, all 50 states, we're all over the board. There are ones that say no, there are ones that say yes, ones that agree with Mr. Fresh and Mr. Papineau, one that agree with the majority of the Court of Appeals. Mr. Fresh and I were discussing this morning.
You've not come with a brand new way to solve the problem. that
I wish
everyone's-
I could. I wish I could. Shortly after the Ohio case Mr. Fresh talked about, a Hawaii case came out and said exactly what I'm asking this court to do, affirm the Court of Appeals. I don't know the answer to this. I know that the children ultimately are the beneficiaries of any overpayment, any Social Security lump sum payment, and possibly that's what we ought to look for. Fortunately, both of these parents, excluding when Mr. Papineau became disabled, were in the medical profession. They were both professionals. They both did a good job, and it was very much agreed to settlement, and they've gotten along wonderfully with kids. But now we're talking about $5,600. Here we are in front of you. I don't think anyone's hurt by affirming the Court of Appeals. I think the children benefit. I stand for any questions.
It just seems at least counterintuitive to call something a gift where the non-payment of that gift could have resulted in a show cause hearing, why he shouldn't be held in contempt for not paying his payments.
I have to agree with you, Justice Johnson, but that was, I agree.
And I disagree. I guess I think the people who are, the folks who are hurt are going to be the children of the next person who goes and asks a lawyer, should I pay this while I'm waiting for my Social Security disability retroactive payment? And any lawyer, if we do what you say, any lawyer is going to say, absolutely not.
Justice
Don't pay
Barnes,
it until you get, till the money comes in, and then we'll get credited back.
On the other side of that, Justice Biles, the only thing I can say is a lot of times the money doesn't come in. The Social Security claim is turned down, and as you well know, they can last 4 or 5 months or 7 months, as in this case, or 4 or 5 years before anything happens. I don't think I could, in good conscience, say to a client, don't pay your child support, violate this court order, because you're going to get Social Security. And I don't think any lawyer would really truthfully say violate a court order. I would explain to them the situation, but I couldn't advise them to violate a court order.
Any more questions? Thank you, counsel.
Thank you.
And maybe you addressed this in your opening, but what are you seeking here exactly? What is to happen?
Your Honor, we're seeking two things. One, we're seeking an order that Mr. Papineau be paid back the months that were duplicated by the,
Paid back by who?
paid back by the mother. We're seeking that, and I guess we're also seeking some guidance going forward. And Justice Biles, I would like to address the question that you posed to Mr. Ferris. I can foresee a situation where a client is going to come to my office and ask me, you know, I got hurt at work, or I have a health condition or whatever, and I'm applying for disability, and what about my child support? And I'm going to tell them, number one, as Mr. Ferris said, absolutely, you have to follow the court order. You're ordered to pay child support. You cannot violate that order. You can be punished by the court, you can be jailed, your property can be taken, whatever. But, as you said, then the second thing I have to tell them is, but under our current law, if and when you get Social Security disability 2 years, 3 years down the road, there's going to be a lump sum retroactive payment made to your children, and you're not going to get anything back, so you're going to pay twice. Now, I think most people are honorable. I think most people who are ordered to pay child support or ordered to do things in domestic cases, they may not like them, they may not be happy about them, but I think they...
How is your client paying twice? The client's paying child support, and then he's paid into Social Security, and a benefit of that is that his children are entitled to support. He's not paying it. Social Security's paying it. I mean, it's a benefit that he derives from putting into Social Security all these years. The children receive a double payment, but he's not paying twice.
He's paid into, well, he has, Your Honor, because he was receiving the disability insurance benefit and using part of that to pay his child support.
Right.
Just like if he would have sold his boat and used the money to pay his child support, or tapped into a retirement account and paid his child support. He also paid into the Social Security. The children are entitled to the support, and they're entitled to receive it once, and I think, and maybe it's in the dissent in this case.
But that was, just so we're clear, that was the children's Social Security benefit, not his benefit.
That's
He got a
correct.
separate benefit for him, and he did not take any of that money to go to the
That's- that
children.
was-
Correct,
Right.
correct.
It's a
They
separate
receive their own,
benefit under federal law
But
to the
it's-
kids.
but it's based on what he paid in.
Sure, but he's not paying it out of his pocket now.
He's not, and it does not reduce what he would have otherwise
And for that
gotten.
matter, in the subrogation matter, it's not money that went to him. It's money that was designated for the children and went to the children via the payee mother.
The,
Well, you mentioned the subrogation claim.
the subrogation is to the total of the disability insurance that was paid.
I understand that may be what they're claiming, but it's not his money. It never was his money. That's my point. So how can they have a subrogation claim against the kids? They don't, against the money that went.
It's
to
not
the
against the kids, it's against him, but it's based
think
on
we
money he received and then paid.
And I want to clarify, do I recall that mom took that lump sum and put it in a college fund?
That's what we've been told.
Okay. And so just to clarify, you agree that she cannot take that money out of that college fund that belongs to the kid and pay that to your client? That would violate her obligations under federal law.
I think that would violate her obligations as the representative payee to use the money solely for the benefit of the children, but parents often have to pay other parents for things that they paid for children, like uninsured medical expenses. If you take a child, if Mr. Papineau's ex-wife takes the children to the doctor and there's a $50 copayment, she pays that, and then he may be obligated to pay that back to her. or if he paid it, she'd be obligated to pay him. So I don't think it's really all that far of a reach to ask that she be obligated to pay that, even though the children receive the benefit of it. They receive the benefit of the health care that has the deductible. I think, if I might, and I'm out of time, and I apologize, the policy should be to encourage parents to pay support regardless. And the state of the law right now is a major disincentive for parents to make an effort to do that, regardless of how you look at it or where the money comes from. And this question has never been squarely in front of this court. We'd ask you to consider that policy, not just for Mr. Papineau, but for everybody in the future that's going to be in his situation.
To put it in perspective, you're saying the policy should be to encourage payors not to violate a court order. Because that's what we're talking about. Not encourage them to make voluntary payments, but to encourage them to pay the money that they've been ordered by a court to pay.
Yes, sir, and if you look at the opinion of the Ohio Appellate Court that I referred to earlier, that's exactly what their reasoning is that they want to encourage parents to provide support for their children regardless of the short-term hardship.
Any more questions? Thank you, counsel.
Thank you very much.
Thank you both for your arguments this afternoon. Court will take this matter under advisement. That concludes this